My lords, can we hear me? My lords, may I mention this matter, my lords?
Flag D, my lord.
May I mention the matter, my lords? With my lord's permission, may I mention a matter?
Leave it.
My lord, with my lord's permission, may I mention a matter, my lords? Am I audible, my lords?
How many you are there from 23 to 2023?
I am in custody from 17th of May 2020, your lordship.
No, the petitioner surrendered on 23.
Yes, sir, I surrendered.
So
Once
you were on bail
for 1 month.
or whatever.
Yes, your lordship. On time, I am surrendered.
You have not misused the liberty.
No, your lordship.
My lord, last occasion, let's say, directed us to take instruction.
Obviously, this
Yes.
is the cause.
Yes.
His daughter is getting married. He has to perform certain rituals. I
Let-
do not know the culture here, but
The same, my lord, the same.
naturally the father has a very big role.
Yes, my lord, the same.
Kanyadan.
That is,
Kanyadan.
Now, my lord, our instruction is that, my lord, whatever they have stated in that IA, in their IA, it is true, my lord. The marriage ceremony is going to be held on 19th, 20th, my lord, and it is true, my lord.
so let him.
What about his conduct?
My lord, so far the conduct is concerned, my lord, last occasion he was released on interim bail. He has not misused his bail that period.
Where is that?
The certificate, your lordship.
Where is that order?
That is order number 4, your lordship.
You were released.
My lords.
Order number
4, dated 17th of January 2023.
And he surrendered before the court on 23rd February 2023.
So
my instruction is there is a ceasefire decided between the parties.
we
There
have
is a ceasefire between the parties agreed upon.
the actual
That's
word
not.
is-
That's
actual
not
word is-
devil's
the
going
actual
to-
word is a truce.
Truce.
But yesterday's instruction there is a truce they have agreed upon. So next date will fix. I think in between the government they will settle.
Under that connected item,
Then
20300,
new
Everything is there.
This is not correct.
Madam. That's why I'm praying that to detach that matter 20300, that is a single judge
If it is
matter.
going to be settled, we are not going to do it. Just take.
But I don't have any such instruction. Whatever my learned senior is saying that.
Senior counsel.
Yes,
it's
yes,
a
I-
responsibility. I
Yes.
believe that everything would be done.
Otherwise, government is saying that there is no.
Mr.
So
Das, do
this
you have
time
any?
the positive vibes have come from the government.
They are also there. Yes. Silence speaks many. Silence speaks a lot.
In both ways.
Give granted. So we have not seen whether.
Item number 3.
Yes, what's wrong has been committed by my brother. Why? Why do you?
It was because of the change in circumstance.
May
Change in law.
before my learned senior
Sorry,
begins,
you're right. What wrong we have committed,
before,
not my brother, we have.
may I submit one thing, Milord, before my learned senior begins, Milord, may I submit one thing, Milord? Turn to page 16, Milord.
That's the judge.
No, Milord. That's a kindly see.
What?
But
Counsel appearing for the petitioner.
Oh,
Same council.
who is appearing in,
Other
Review.
council. Other councilman.
you are appearing? You know the judgment,
Milord, so
AIR 1997 Supreme Court. If I am not wrong,
Back of your
106 or 7.
my lord has delivered on judgment. Attached.
Grant me some time. Please brief if he can engage.
As a senior counsel,
Yes, my lord, but as a senior. Come through it.
First day's delay.
262 days.
What is the ground?
Ground that,
10-sitter.
yes, that will be. Waiting for the larger bench. Only after the larger bench, I was tempted to file this.
Can that be a ground?
As your lordship pleases, if your lordship disposes of all right, otherwise I will ask my client to.
But the section 5
Section 5.
is a big hurdle. Take instructions.
Yes, ma'am.
The
Ma'am.
let him take a chance.
Item number 4.
Oh, bless.
Lordship's order, my lord.
15/4/2025, then para Lordship's order dated 15/4/2025.
Yes.
My lord, Lordship's order dated 15/4/2025. Para 11 was the specific direction, my lord, for which I have filed this present contempt
Para?
application. Para 11, my lord, that I have quoted in page 3. So far as the application made by the petitioner for modification of the mining plan and to provide alternative site to the petitioner for mining
But we
operation.
want to take a decision as
My lord,
earlier.
we have filed an application. They have not taken a decision. I have filed an additional affidavit. There, my lord, I have annexed 2 letters. Now, what they have done is, my lord, after we have filed the contempt application, they have asked me to appear before them. And after I have appeared before them, Lordship, may kindly take up my additional affidavit. The Tahsildar has been directed. I have provided an alternative site. The Tahsildar has been directed to verify that site and give a report. That has not been done. Thereafter, the DFO has been directed to verify that site. That also has not been done. That is in October 2025. Now we are in April 2026, madam.
No, my lord, pursuant to the direction of the Honorable Court, Your Lordship may kindly have a glance to the show cause affidavit. In fact, it has been termed as compliance affidavit, but that should have been the show cause affidavit. Lordship may kindly see Annexure C/1. A proceeding of the meeting was convened.
Why show cause? There has not been any show cause which is issued upon.
Not issued, but only
You presume that a show cause will be issued against you?
My lord, in fact, we have said it as a compliance affidavit. We have filed it as a compliance affidavit, but that may not be termed as a full compliance of the order. If your lordship may kindly see Annexure C/1 to that affidavit, page 28.
C/2.
C/1. Page 28 of that compliance affidavit that is filed by the one Jaiprakash Naik, Deputy Director of Mines.
That copy has not been given.
Plug B.
Copy has not been given.
Page 28.
Page 28.
Page
I do not
20.
think there is any page 28, sir.
Ah,
Your compliance affidavit ends at page 21.
exactly.
What are you holding? Another way?
No, that's a
C.
C is at page 18, I believe. Referring C2.
C/2, man.
This
C/2. I'm
is
sorry.
that page, I believe, is 17 or.
that is show cause.
Page 59. Page 15 C/2. Proceedings of the personal hearing.
Mr. Das,
Yes.
there are two compliance affidavits.
Yes,
Plug A and plug B. Which one you are referring?
Affirmed on.
But one affirmed on 7/11/25 and the other one on 27/10/25.
So you are
You are referring to
one.
which one?
But your lordship may take up that 7/11/25.
That
That was filed on
711. So it is at page.
page 15, man.
15.
yes,
C/2.
yes.
Yes.
So lordship may look at that proceeding. There was a threadbare discussion, and the petitioner was represented by one of his representative who expressed satisfaction over the personal hearing also. So lordship will find that 1, 2, 3, 4. In the
So
fifth.
you say that you wanted a forest the clearance as well.
Yes, as well as the Tahsildar has
Because
to
of the common cause judgment.
common cause judgment, the Tahsildar has because they want the shifting of
I understood.
Yes.
Wanted shifting.
yes
Wanted to have an inspection.
inspection, and
And
the
then
Tahsildar has to produce that correlation map and the feasibility report. Now today, just now I received the instruction that the Tahsildar has already furnished the report to the mining officer. So they will take a decision within 15 days, my lord. And the DFO report also, the forest clearance also they have sought for.
That submission be recorded and the matter, let my honor print submission be recorded.
The instant content applications is by
for restoration.
Restoration list.
My lord.
Restoration,
My lord. Dismissed for non-prosecution.
when it was dismissed for default,
2/12/21.
where is the application and where do I get the order?
Page 8. Page 8. Running page 10 is the order.
Dismissal by order of the registry.
No, my lord. Your
When the
lordship.
application is filed,
Application is fine in 25. There is a delay of
no, not by registry. By you.
Right.
Yes,
there is a delay of 1385 days.
so what you are doing, sir, what is the expectation?
No, it is 1427 days. 1427.
Report 9.
1427.
1427 as per the.
Yeah, what is the explanation, sir?
I have given a medical certificate.
How much?
Further affidavit I filed on 10th of April. I have given the copy. Lordship will find that at annexure X. Suffering from chronic osteoarthritis of lumbar sacral joint with DM type 3 and hypertension, he was unfit and was advised rest and restriction of movement.
Hypertension is no more a disease. We are also suffering from
Other part is that arthritis lumbar sacral.
It is your gift to us. Hypertension.
Made certain allegations against the erstwhile lawyer. Can you secure his presence?
That I have talked to my client.
If you are making some kind of an aspersion.
Because
against
only
the
thing is
erstwhile
that
lawyer,
he did not inform
no,
for 3-4
sir,
months.
then he should come whether he
My
has
lord,
informed and notice who is the earlier
Mr. Pal, don't indulge in such kind of practice. It's a very bad thing. Making allegation against your own colleague.
I don't stand by.
Sir, paragraph 3 you have said.
Yes, I know. That is the
So-
instruction because
So you'll have to, who was that? You don't know how you accepted the brief for restoration.
dismissed.
Okay.
So once it is dismissed, his
No, sir.
Vakalatnama gets
No, sir.
discharged.
Restoration is within the matter. It's not a. You are filing it within the matter.
Let me take instruction.
You'll
I'll
have
get
to-
the
you'll
email.
have to-
Yes,
you'll-
yes.
We will direct you to give a notice to that advocate. Let him come. Let him justify, yes, whether this is correct or not correct. He may have some versions.
Without hearing him, we can't talk about.
Considering the
It's an item number 1.
No, where is our order?
Page 12, ballot.
Page
Page 12, ballot.
Sir, what is this? Page 12.
Lordship may kindly come to from page 14, ballot. Well, I will not trouble the Lordship with regard to paragraph 3, 4, 5, 6, 7. And Lordship may kindly come to paragraph 9 and question. Let,
Your writ petition got dismissed.
it was
If any observations made, does it tantamount to a contemptuous act?
Lordship may just see Malak observe.
I've seen it is open. I've said after I'm looking at paragraph 9 and 10 both.
Yes.
10 was unwarranted. It was surpluses.
Well,
Once you say it has become infructuous and the writ is dismissed.
I'm saying, Malad, why it was said so, Malad? Lordship just sees
So,
one,
sir,
only one.
you show us that the writ petition is dismissed and observation made in the writ petition
Well,
while dismissing
what about?
whether that tantamounts to or a violation thereof.
Well, I'm answering to Malad's query, Malad. The writ petition, disposal of the writ petition is on the basis of Malad.
It's not a disposal, sir. It's a dismissal. It has become infructuous. Though the word disposed of is used, but it is really a dismissal.
Malad, let's say just sees Malad only one paragraph. See, Malad.
Oh, no, whatever we understood, but it's still
Malad, in fact, Malad, the Puja Committee, the commissioner endowment, Malad directed the assistant commissioner that since the Malad some leases have been in possession and the lease period is expiring, that is the reason, Malad, they have to be given preference. That Let me just see page 83, paragraph 12, Malad. What's with me, Malad?
Contempt act. Contempt of court.
contempt of court.
Let's in the when I disposed of petition, paragraphs 9 and 10, my lord, are, my lord, the follow-up of what is at page 83, paragraph 12. Let's Lordship just sees that only one paragraph, and then I'll leave to my lord. But paragraph 12 reads like this at page 83, my lord. The assistant commission, let me read it from the relevant line, my lord. As most of the shopkeepers have made huge investment, instead of vacating them, they may be offered to continue as lessee if they are ready to pay the rent as to be fixed by the Assistant Commissioner of Endowment Bhubaneswar, and are also ready to execute fresh release deeds with the trust board with the basic terms and conditions of which is to be decided by the Assistant Commissioner Endowment Bhubaneswar. Well, because of this direction, my lord, in fact, the application, the orders at page 9 and 10 gets surfaced. Well, so this is what has not been done by Malad, the opposite part number 4. This is my only Malad contention philosophy. Malad, somebody, an intruder, Malad, comes into my shop room, and then Malad, he remains in possession. I come to this honorable court, and I place this particular document before this honorable court, for which Malad, the writ application was disposed of with the observation of 9 and 10. Well, then the commissioner's order becomes odious, Malad.
Not odious in that sense. Not odious in that sense.
Well, it has no meaning at all.
You were blessed with this kind of an order. You were blessed. It is not that this order was not in existence when the writ petition was dismissed.
When the petition was disposed of, this was shown to this honorable court,
so
and based upon this, it was the order passed.
Despite of the court would have said straight away that I'm modifying or molding the relief in view of a subsequent disclosure of the facts, and then directing them to allot the shop in your name by evicting the another person.
That's what I'm saying. Has the opposite party taken a decision? No, they have not taken a decision. What should they seize the paragraph?
So they could have, but it was not saying that it is infructuous, and then there was no reason.
Well, at the OP number 4 pursuant to para 10 has not taken any decision at all. They cannot wash away or sway away from the responsibility of adhering to what has been said in paragraph 10. They should take a decision, to comply with the order. Because they are the people to allot.
So that is what they will say there, whom to be allotted. Actually, your
let them say so, Let them say so,
Your period expired.
But period is expired.
So they say that there is no question of any allotment in your favor.
Because
your husband was the allottee.
That they don't say,
Whatever that what is a paragraph 9 it comes. That's the observation of the division bench. That since the lease has expired, there is no right which is accrued in you.
That is what the commissioner
and somebody is already there in position and he is running it. It is open to the authorities to take a decision what to do. At least vis-a-vis the opposite party number 5, you have no clue. That is what it says. No, sir. No, sir.
What best possible thing could be placed? I have placed Dr. Balance.
So this came up. And subsequently, the limitation has come. You have come after 1 year. The order was passed in the month of July. You have filed in the month of October.
Well, I went on representing them.
Whatever.
By showing
whatever. That too, your right of fructify. Anyhow, we are not going to the limitation. But into this. The contempt application.
But on the last occasion, this honorable court had directed to had been pleased to issue notice on the question of limitation and admission. My lords, notice on the private opposite parties has not been sufficient, my lords. So I pray for one to file fresh requisites to take fresh notice on the OP 5 and 6.
There is a meeting that notice to implement. That is what I've said. Either by way of publication.
Let's see the last order, paragraph 6, some directions were issued to the
Petitioner has complied the request.
No,
Not
Yes,
complied.
not
I have already complied, Your Lordship.
When?
Last 10 days, Your Lordship.
Date give me date. Give me when you complied the request made by the Tahsildar. What is the date?
Your
That
Lordship.
was the order. You have to comply the request made by the Tahsildar under Annexure B by 3.
Yeah, Annexure B, as per the Annexure B by 3, I have already complied.
When? If just a date.
Date,
Saying that it's complied, that will not help.
I have already complied, Your Lordship. Physically.
In what sense?
Well,
In
date,
what sense? You just tell me how you have complied. What you have done.
my Aadhaar and my legal hair certificate, I have already produced before.
Where is the acknowledgement by the Tahsildar that we have produced all those documents before him? Where is the acknowledgement? Show me the acknowledgement. So that you must have submitted by what document memo, na? Where is that memo?
Yes.
Comply the request first.
Yes, Your Lordship. I have already complied for the
There is no document forthcoming from your side showing that you have complied, sir. We are saying either you just file an affidavit or give us some document.
Yes. Your Lordship, next Friday I have also filed my along with him affidavit, Your Lordship.
For the
Item number 2.
There is a review also. The review was filed by the state, Your Lordship.
Condonation in a contempt?
No, no, Lordship, that I submitted on the first day to Lordship, that I will not be placing it to the.
Filing the contempt application.
No, there is no delay.
Then why you file an IA? Withdraw that IA.
I already on the first date only I had submitted and not placed that IA.
And the IA will dispose of not placed. IA will dispose of not placed. Submission. This court held that the order in the case of Anandas will be made applicable. They have not complied.
They have not complied. They have filed a review on the last order. If your Lordship see in the contempt,
The review is dismissed.
the review is there on board, your Lordship, today. It has been tagged along with the contempt.
Where is the review? Where is the review? Now the review is pending or it is disposed of?
Pending, your Lordship.
Pending.
Your Lordship.
So then review has to be had fast.
Your Lordship. There is a delay of 551 days, your Lordship, in that review.
In that review,
Even after they.
Whether notice is issued?
This is coming on for the first time, your Lordship. Coming for the first time. The review is also coming for the first time.
Sir,
No, they have filed a review. The state has filed. I have received the copy.
filed a review.
Yes.
Have you served the note?
I will serve that.
I have been served with the copy.
have you filed an objection in the IA?
Copy to the end.
No, your Lordship, I have not filed. I will file an objection.
No, will you want to file or will you?
There is a deal. You can show the.
Sorry, unless you file an objection,
Lordship.
you have to
Would you
file.
like to oppose?
Your
or
Lordship,
you
I'll
want
be.
you want to give a consent for
No, 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 I'll be opposing, your Lordship.
Sir, IA 83 of content notice.
Yes. Opposition. I mean, here the counter.
Objection. Objection to that.
Objection. We call it evidence. Consent for the opposition. It is a review.
Item number 3.
My lord,
Where is the direction, sir?
my lord, your lordship may kindly see the last order where is learned the Union of India had taken time to obtain instruction why the order has not yet been complied.
Today you are filing.
My lord, once they have filed so cause to the affidavit that has been rejected by this honorable court.
Huh?
So yes, my lord. My lord, may kindly
Say,
see
my lord, but
order
they are not
that says-
satisfied with this affidavit. So you
order
file
that
it.
says, my lord, 25/1/24.
25/1,
24.
25/1.
The earlier show cause is rejected.
My lord.
And this
So
court
on the
directed,
last occasion, your lordship said that
this court directed for filing a complaints affidavit.
yes,
Whether that has been filed.
no,
Today you
only to comply the
today you are filed.
Complaints affidavit.
Yes. Today you are
So,
filed.
a copy.
my lord, what they have done during the pendency of the contempt.
Go through it, Mr. Tripathi, go through it.
My lord,
Then make a submission.
my lord.
Have you perused the abovements made in this compliance report? You have not.
No.
Once you not read the abovements, I think it will not be proper to make any
Yes,
submissions.
my lord.
Just go through it.
My
peruse it,
Complaints affidavit filed in court to kept in the
Copy whereof has been
copy has been
submitted.
on the request. Go through it, and if you want to file an objection, also file it.
My lord.
Item 4.
My lord, the last occasion on 13/2,
Notices were resolved. Last occasion, my lord, please to issue notice. First time it is listed. We seek some time to file its focus. So this
Notice has gone on the last
notice
occasion.
is on the last date. So I am praying for time. Today also file a petition for time also. So let me give some time.
Petition for time.
Because we are explaining there that why you are seeking time. Because it is all India scenery has been affected for this time. If my oral prayer, my lord is allowed. Yes.
File or so cause, Mr.
Yes.
Yeah, that is what is surprising to me. That's why.
Your fear there, Mr. Mukta is terrible.
Rather than opposition to the contempt application within.
So I have filed one IA 151 of 2020 that has not been listed on the board.
In content, Mr.
With the content itself in violation.
Then it is a further contempt.
Further contempt. That is what I am bringing to
let them deal with both the opposition by 4 weeks.
Item number 5.
May I please, your lordship?
Yes, Mr. Manti, this order has been confirmed
My
by the
lord.
appellate court.
Yes, my
So
lord.
you have to comply.
Yes, Mr. Pani is appearing in this case.
Have you complied?
No, my
My
lord.
lords, it's like this, my lord. We'll be filing our reply in this. Lord, and Attorney General has been appearing in this matter. What had happened in the meantime, we have also filed another writ petition long before, because 15 onwards, these are the land hostie, the petitioners, contempt petitioners.
We are
So
not
the
nor we are deterred by any kind of a further litigation already
no,
ensued.
that my lord, I am not on that. Let me file my SOCOS to this.
Direction pass in this particular matter, the writ petition has been complied with or not. When the apex court has also dismissed your SLP.
Yes.
Correct.
So
Lord, even I'll just put it to your lordship. My lord, I am only saying that your lordship may give me some time to file my reply. I'll
No,
just
no reply,
explain
Mr.
that.
You have to file the complaint. When the order has been upheld by the appellate court, you have to file the complaints affidavit. No reply, no objection, nothing else.
My lord, the fact remains, your lordship will just appreciate. I'm only saying that Lord, Attorney General has to appear in the matter. I'm just little handicapped for that purpose. Lord, have it any day, subject to next week, any day. We'll just post it on this.
Lordship. Lordship, with due respect,
The,
I miss.
essentially, the matter is some sort.
I am for the petitioner, the contempt.
I'm appearing with. Yes.
Lordship, we are the land hostage from since 1985. They are just lingering the matter,
Yes.
going to the apex court, then coming to the high court, filing review, then going to the apex court, filing review. Lordship, then they are taking time to file show cause, which is, I think so, which is absolutely.
Right, a person cannot be punished.
Lordship, they are not even compensating half of the amount. They're not even giving compensation to the land hostage half of the amount.
I understand. That is what is. I just wanted a time. We will definitely sit and we will make it as a peremptory direction so that they will come and argue the matter. That's all.
Lord, as regard to Lord, that's my second submission, Lord. Your lordship is just subject to your lordship's indulgence. There's a matter which this is at the land hostie. They are the people who are in 87. Possession has not been given it to us. Precondition because these are the land hostie in lieu of the land they want.
We were available to you in the writ petition. You might have taken or might not have taken. In both situations, you cannot reopen in the contempt jurisdiction.
I agree, my lord. I am not on that. My lord, I am only saying.
Only with the compliance or.
But I completely agree with your lordships. But I'm completely agree with you, Lord. So what I'm saying, the repercussion of that petition which has been pending before, that will have some, because this is a denotification of the land which we are asking for this.
Whatever, you can't do it.
Very well, Lord. We'll take. Lord, may I have it as a
See of the directions by all means.
It has been confirmed by the
Well,
appeals court. Review has been dismissed by the appeals court. So what
yes.
further opportunity?
That's in fact that I can. That's uncontroverted. That
I'll file the complaint.
Lord, we'll just file my affidavit. Just give me some 2 weeks time, so we'll do that, and we'll argue the matter.
Complaints affidavit will be filed. Matters are similar.
All other matters are similar. In fact, that the other court is also seized with some.
Contempt. You are in contempt.
I know, Lord. I'm quite agree of this. But I quite agree of this. We'll look into it.
Yes.
All the matters same.
Yes, sir. Right.
Similar order.
5, 6, 7,
Milord,
and
by
8.
fixing of any date, particular date, it'll be easy. Milord, will be just convenient for us.
Come on 8th May, Mr. Pani.
8th May. Very well.
7, 8, all same.
Yes.
5, 6,
5, 6, 7, 8.
5.
It is.
Sir.
We have considered at length the entire submissions, and our observation is, apart from the fact that we do not find any material error manifest on the face of the order, in the writ application, we cannot revisit the judgment by matter being re-argued before us in review. In view of the discussions made above, the review application being devoid of any merit is dismissed, no costs. My lord has agreed.
Grateful. Yes, I agree.
Item number 2, RVWPET 96 of 2025.
We have noted your submission that another counsel should not argue, but we have taken a lenient view that it's a workman, and Mr. Pani said he is unable to engage any other counsel. But we agree with your submission that other counsel should not have argued. We do not find any material error manifest on the face of the judgment in the writ application, nor we can persuade it to revisit the judgment. We can be persuaded to revisit the judgment on the matter being re-argued. In view of the discussions made above, the review application being devoid of any merit fails. It has to be and is dismissed.
Yes, I agree.
Item number 3, RBWPET 153 of 2025.
In view of the discussions made above, the review application being devoid of any merit has to be and is dismissed. No costs.
I agree.
Notice admission 11/6, that was heard, my lords, and your lordship said that we'll dictate the order in the court. That has not come, my lords. Can I give the memo?
Item 29. Negotiation is going on after vacation.
Wait.
29.
I'm hardly getting time to sit, so don't. Let us wait. You just give to.
After notice matter.
Appear, don't worry. It will appear one day. Next week it will appear.
The conducting council father is passed away.
I have helped. I have relied upon certain judgments, and I have said that no appeal lies below. Apart from that, I have also taken some innovative views below. Apart from the exposition of law as enunciated herein above, another facet in relation to a right to an appeal against an order passed by the appellate court can also be looked into. Although the appellate court is vested with the power to exercise the powers conferred under the courts of our original jurisdiction by virtue of subsection jurisdiction, it admits no ambiguity that the appeal is a continuation of a lease and not the continuation of the suit. Thus, it is only the procedural aspect which can be exercised by the appellate court, but cannot convert itself into a court of original jurisdiction. Therefore, subsection 2 of section 107 does not override nor whittle down the efficacies of the provisions contained under section 104 of the court, more particularly subsection 2 thereof. In the event the remedy against the final order is not an appeal, An appeal against the interlocutory order, even if provided in the procedural part, cannot be conferred nor be assumed. It will get further impetus by incorporation of subsection 2 of section 104 of the court, which creates a complete embargo in filing the further appeal against any order passed in an appeal under section 104 of the court. The moment the final order is passed in such category of the appeal, and an embargo is created to challenge the said order by filing a further appeal in the higher forum, it leads to an inescapable conclusion that any order passed in the said appeal is not amenable to be challenged by way of further appeal. Dismiss.
My lord, in fact, the prayer, my lord, was for conversion, and we had even filed a petition on 17/3 a months back.
File it.
Oh, no, it has been months back. It was filed.
There is one judgment of the
That's right.
Supreme Court which creates a problem. File it. There is no limitation for 227.
That's true.
May I, my lord, mention a matter, my lord, if my lord's kind permission? My lords.
Item number 2.
My lords, may I mention a matter?
This is a civil division, in fact, challenging a final order passed under the Waqf Act, because there is no appeal. So a suit was filed.
Section 89 Waqf Act.
Yes, 83 and clause 9. Section 83, subsection 9, there is no appeal. Therefore, this has been filed. In fact, I am suggesting, Lord, one more time is necessary, adjournment is necessary, so that I can prepare a written note and I will clarify for final hearing.
Are you not confident of oral submission?
Yes, I am just because of factual aspects.
There is Justice Karthi's judgment of the Supreme Court on Waqf, and there is another judgment of 2022.
Yes, I will find it out. Because after 24th, any day, any next sitting will available.
Next.
May I mention a matter, my lord, sir?
What is the nature of the order?
I am for the opposite party now.
The Waqf Act. How 115 lives? How 115 lives?
Well, in this case, the petitioner died.
I'm asking you whether 115 is the proper remedy.
Within 90.
It's not a court. If it is not a court, then 115 and I can understand the another provision, but not 115.
No.
Tell me, sir.
It is filed by the petitioner. I am the opposite party.
Who is for the petitioner? How? Sorry, I put a right question to a wrong person.
Lordship,
How 115 lies, sir? Look at the language of section 115, what it says. It's an order of the court. Whether the Waqf Tribunal is a court.
Lordship, I am appearing on behalf of Mr. Devashish Tripathi.
Sorry, we can't. You can't, sir. This will be absolutely a futile exercise if we list those matters. Every time you will ask for an adjournment, and it's very difficult to sit. That's why we gave 2 days before the notice that I will be sitting here. No, sir.
Lordship, only short sir had to.
Who is the advocate in record? Who signed the Ogalatnama?
Mr. Devashish Tripathi. Mr. Devashish Tripathi.
Where is he?
Sir had to leave due to Sir had to leave suddenly due to on ground of his ill health.
What?
On ground of Sir suddenly had to leave.
I was there for 19 years. I know the grounds of adjournment. Where is he? Call him.
Sir, he's not here, sir.
I'm sending one of your colleagues there in the Bar Association.
Sir, he's not.
15 can will go. Well, adjourn, what can we do?
Item number 4.
Have you got any recordings in this case?
My lord, I'm on Vishy, my lord. I'm on virtual mode, my lord.
Yes. Is under challenge, sir.
My lord, my lord, here,
Yes, sir. This is again 115. Now 115 lies against the order passed in the first appeal, sir. Tell me.
I'll examine, my lord.
Tell me.
I'll examine, my lord.
13.
Your lord.
13 application.
My lord, order 39 rule, my lord.
No, not order 39. It is order 9 rule 30.
Order 9 rule 13.
Setting aside the ex parte decree.
The ex parte decree.
Are allowed.
My lord, ex parte decree was, my lord, that was rejected by the London trial court, and
Sir,
on
order
appeal.
13, you are a defendant, obviously.
No, I am the plaintiff, my lord.
Plaintiff.
Plaintiff
So,
in the suit, my
what
lord.
ex parte decree?
I am the plaintiff in the suit, my lord.
You are a plaintiff in a suit. That means you got the ex parte decree.
Yes, ma'am.
Then the defendant filed an application for setting aside the ex parte decree under order 9 rule 13.
Yes, madam.
That is to dismiss means you are a successful litigant in the trial court.
Yes, madam.
Then first appeal is filed by the defendant.
No, my lord. They, my lord, filed application, my lord, to set aside the ex parte order.
Sorry?
That
I know it, sir. But their application got dismissed. I find from the order dated 18/8/2010 in MJC 11 of 2002 that order 9 rule 13 application is dismissed.
Is dismissed, my lord.
That
and
means
as against that, my lord, the state filed an appeal, and the appeal was, my lord, allowed, directing to hear the appeal, allowed, my lord, to hear the matter, the MJC, man, the petition for setting aside the ex parte decree. It was only.
where is the order of the appellate court?
Yes, my lord. That is, my lord, from page 21, running page 21 to 30, page 21 to 34.
Page?
21, my lord, running page 21. Order of the learned appellate court, man.
Which for the other side?
Is the state, man.
Yes.
Opposite party, they are the opposite parties of the state, man. Collector, man. My lord, may I submit the background fact of the case, man? Why the learned submit the background fact of the case? Why the application, my lord, were rejected by the learned trial?
I am more on a basic fundamental principles. You have invoked the jurisdiction of 115.
Yes, ma'am.
I just wanted to know whether 115 lies. Tell me, sir, 115 lies.
My lord, after the CPC amendment in 2002, my lord, I believe, my lord, it should be a CMP, my lord.
No, CMP is one thing.
Yes, ma'am.
You are invoking 115, sir.
Revisional jurisdiction of the court.
Asking whether 115 would lie.
That the principal, my lord, if it is taken into consideration, if the application had been allowed, then it would have disposed of the suit. But here the application is filed by the state.
Yes, what is the point?
My lord, here, my grievance is, my lord, I, my lord, purchased a piece of land, my lord, from a gentleman who had got that property from the ex-intermediary man. There is a
We can't enter into the merit. We will
no, why? I'm not going to the merit, my lord. The background basic facts, my lord. The basic fact is, my lord, I filed a suit for declaration of right title interest, my lord.
Yes.
And in that suit, my lord, I filed in the year 1992, my lord. That is on 26th of February 1992, 21st of January 94, I filed. Then, my lord, the case, my lord, was adjourned from time to time, and the collector, my lord, did not cooperate, and the dates were, my lord, being given. Ultimately, the case was heard ex parte, and the judgment was delivered, ex parte judgment was delivered on 26th of February 1994, my lord. 26th of February 1994. Thereafter, one MJC was filed, my lord, to restore the suit by setting aside the ex parte judgment, my lord. That was allowed, my lord, with a cost. But then, my lord, that was allowed subject to payment of cost, my lord. But that cost was also not paid within the time granted by the trial court, and ultimately the suit was, my lord, dismissed. Again, my lord, they filed an application to recall that under section 151 they filed an application. Court being, my lord, considered it, my lord, allowed the application and asked them to pay an additional cost also. But that after that also, my lord, they did not cooperate in the suit. It went on from time to time, and ultimately, court finding no other alternative, my lord, dismissed the suit, my lord, ex parte again, because of several adjournments and their non-cooperation, my lord.
Sir, you are a plaintiff. How can a suit be dismissed?
I am sorry, my lord. Suit that application, my lord, was rejected. I am sorry, my lord. That application, my lord, to set aside the ex parte order, that was rejected, by on the ground that there is a sufficient delay also, and there is no motion, and you have not been attending the court time and again. That is the case, my lord. After that, my lord, they, my lord, set over the matter, and the ex parte decree, judgment and decree remained final. That was passed in the year 1996, my lord. In the year 2002, my lord, in the year 2002, my lord, one encroachment case was initiated against me in respect of the very same land on which, my lord, I had obtained a decree from the civil court. My lord came up with an application to, my lord, set aside that order and to hear the matter again. And they filed an application, my lord, for condonation of delay in not in coming in time. Court, my lord, taking into consideration the fact that since 92 you have not been cooperating, the judgment was passed, and 2 times also ex parte judgment was passed, you did not cooperate, although it was allowed and to pay the cost. And then finally court was constrained to, my lord, pass the judgment on, my lord, 10/5/1996, my lord. But thereafter also for a long period of, my lord, 6 years, they did not take any step, my lord. And when I, my lord, received a notice in an encroachment proceeding initiated by the Tahsildar, my lord, I appeared before the learned Tahsildar, and I produced him a copy of the judgment. Sir, this is the order that I have obtained from the learned court, and that is also against you. Then, my lord, they filed an application to recall and restore the suit and to condone the delay of, my lord, more than 6 years. On taking into consideration these facts, my lord, the learned trial court came to the finding that even for more than 6 years, you have not given any sufficient cause to satisfy the court that there was a bona fide problem for which you could not participate in the proceeding. And also, my lord, one more relevant fact is this suit, which was, my lord, allowed ex parte in my favor, taking a copy of that judgment, my lord, similarly placed persons, my lord. It's a vast chunk of land. Poor people, they have been in possession of 6 cents of land, and they have constructed a dwelling house there. Others also had approached the learned trial court in various suits, man. In 1999, 2000, likewise, but that is also discussed by the learned trial court, man. And my ex parte judgment was cited in the trial court, in the very same court, in respect of other persons who had also approached the court. And the learned trial court, taking into the consideration, my lord, the ex parte judgment that was passed in my favor in the year 1996 allowed the suits of various persons, man, including one in the year 1996, man, 1999, man. I've also given the number of the suit matter, that is title suit number 3 of 1999 matter. And various persons were also matter in my favor in the year 1999. But then also they did not take any step. Although they knew that I had obtained a judgment and that was also placed in subsequent cases by different persons, but they never took any steps for that. That is why, my lord, under trial court, taking into consideration all these facts, here discussed.
Close all those facts in your objection to Order 9/230. What you are arguing, did you
Yes.
disclose those facts in your objection to Order 9/230?
Yes, my lord, that is what also discussed by the learned trial court.
Yes.
My lord.
According to you, they were well aware that
Yes.
this judgment and decree is passed even in 1919.
My humble submission. My humble submission.
Court judgment was relied upon by the plaintiff therein.
Yes.
Their contention that the lawyer never reported nor they ever communicated that the suit has been posted for hearing or decreed ex parte is absolutely a false statement.
That is my humble submission, ma'am. My lord, may kindly turn to my running page 15, my lord. 15
Yes.
on running page 15, my lord. In the brief my lord is holding.
Yeah.
15, my lord. May I be permitted to, my lord, submit from, my lord, paragraph 5, my lord. It is stated suit number, title suit number 3 of 92. That is my suit, my lord. Was for declaration of right title of the plaintiff in respect of a small portion of Basti plot number 282 of Tumbiguda Mouja. Many other suits were similarly filed in the year 2000 and 2001 for portion of the same plot wherein mention of decree passed in title suit number 3 of 92. That is my case, well, found plate. And the Tahsildar Raigada was one of the defendants in those suits. As the defendants in those suits had made that 1999 is also that one, a little later, man. As the defendant in those suits had made their appearances and had filed written statement, the fact that the petitioner had noticed regarding the decree entitled suit number 3 of 92 only on 26/6/2022 on copies of decree of and judgment being filed in the encroachment cases was not true. It is further stated that the fact of decree in title suit number 3 of 92 was also mentioned in title suit number 3 of 1999, which was decreed on dated 27/11/1999. And so it can be stated that the petitioner had the knowledge of disposal of title suit number 3 of 92 by the said date. On the facts prayer has been made to reject the petition filed by the petitioner. The petitioner from his side has examined 2 witnesses, wherein PW1 is the deputy collector both. Both is a different district, my lord. It is in the Raigada district. And PW2 is a junior clerk of the office of the Tahsildar Raigada. None has been examined on behalf of the opposite party, that is myself, my lord, but a certified copy of judgment passed on dated so and so, entitled suit number 1992, has been marked as Exhibit A. On going through the materials put forth by the witnesses of the petitioner, it is found PW1 to have simply brought forth the fact that he came to know of the judgment being passed in title suit number 3 of 92 only after a Xerox copy of the said judgment date on 26/6/2022 in the encroachment case number so and so, which was pending before him. It is also brought on record that it being coming to his office, he had not acknowledged the fact to the collector and the government pleader to make in the said matter. He has exhibited in his letter to the government pleader as an Exhibit 1. Further, the record in encroachment case number so and so has been exhibited as Exhibit 2.
Another point I noticed from the judgment.
Yes, ma'am.
You are not taking that point, but it appears that the Tahsildar who has filed an application under Order 9/230.
He is not a party, man.
He was not a defendant.
No, man. He is not a party also.
So
And there is no no, man. He is not a party in the suit. And also, he was not authorized. He was not.
The application under Order 9/230.
Man, that application 11, my lord.
No, it is by the state of Odisha, not the Tehsildar.
It state of Odisha, but the petition is verification is by the Tahsildar. Your lordship is
What, sir? If somebody is authorized, then it can
no
be
authorization. My humble submission is my lord. Had there been an authorization, had that no, my lord,
technical aspect.
my lord, my humble submission is my lord. It is subject to my lord's kind appreciation. But the petition was filed by the Tahsildar because your lordship is his signature
No,
also
it
there.
is not filed by the. It is, sir. You know who is the petitioner there. He is appearing. Affirmation can be done by any authorized person.
No authorization is there. That was my specific ground also.
Be deemed to have been filed by that person who has verified it.
My
The
lord,
constituted attorney may verify the petition, but does it mean that it is a petition of a constituted attorney? No, it is a petition of the principal.
yes, my lord. I bow down to my lord. But my humble submission is, my lord, subject to what my lord considers. Here,
Anyhow,
my
I
lord,
wanted to say that they had a knowledge prior to
and
the.
there are no authorization. There are no authorization by the collector, the party in the proceeding, to swear the file the petition on his behalf. That is my
This cannot
specific.
be. These are all
All right,
I would
all right.
take them
I'll not,
as-
I'll not take that. I'll not preach that. I'll not preach that. But several persons, and in the meantime, my lord, one more relevant fact, one of the persons, my lord, similarly placed of the same patch of land, he had also filed a suit. Suit was allowed. Appeal was filed. Appeal was dismissed. Then the matter was carried to the Honorable Court, my lord, in RSA number 14 of 2015. That was also dismissed. I have requested my learned friend to my lord there in the court to kindly pass on the order to my lord's kind perusal.
It's for the state. What do you say? Simply because the government pleader did not inform you when you were aware in other proceedings you were represented there. They have cited this judgment. You are aware that this judgment or a decree, ex parte decree is passed against you.
In our knowledge, when the encroachment proceedings were initiated,
So
and when
that
they
by document they have belied. They have shown that this statement that it has come only when the encroachment proceeding was initiated is wrong. It's absolutely false. They say several suits were there. There, this judgment was cited and marked exhibit there. So that was within your knowledge. And still you were sitting over for more than 4 years, 5 years, or 6 years.
but at the time, there was the government pleader did not inform the state regarding those matters and the development in those
We
matters.
were contesting and they did not inform. A document is marked exhibit. Is it believable? Are you a privileged litigant?
No, but the department was in dark regarding the proceedings matters.
Sir,
And since the government pleader had
you
put
find your
forward
written you be said to be in dark.
no, Malas, that was in 1996. Thereafter, in 2000, after the order was passed in 1996 and 2002, because there was no intimation as such by the government pleader, then the state came to know about the proceedings.
Send it to me. I will dictate this order. Keep it on the next day for orders. You are not citing any judgment that the government is not a privileged litigant. He has to. That is why.
I'll avoid, my lord. My lord may give me 1 week time, my lord. In the meantime,
Anyhow, we are keeping it for orders in the next matter.
Well,
Next week.
Item number 5.
Yeah, please. Please.
I am for the opposite party.
On what ground? A, C or D?
I am for the opposite party, my lord.
Sorry, I'm asking you a question. They are not here. 47 rule 11 dismiss.
Yes.
Understood. It was under clause A, C or D. Means non-disclosure of the cause of action or the part.
No, my lord. The suit was filed by the power of attorney holder.
Yes.
And it is contended that the power of attorney was executed by two persons.
Hmm.
And the
Suit is instituted by three.
suit is instituted by one of them. The one of the executant died.
At the time of presentation of the plaint.
Yes, my lord. So therefore, the learned court said that since the unless it is contended that the
it was a joint power of attorney given, or it was a
joint power of attorney given. Joint power of attorney given.
What is the effect of the power of attorney if one of the joint?
If
he dies,
the
does it survive for another?
The learned trial court has referred to the judgment of the apex court and said that since the powers are distinct, so this power of attorney holder can maintain a suit if the one of the executant is alive.
What is the Supreme Court judgment? They relied on Allahabad High Court.
Sorry, Allahabad High Court judgment.
I am asking you whether if it is jointly given, if one of them die, does it survive for the survivor?
I think it will survive.
Show us the law. I think differently.
But
if it is jointly given, it is not a mutually or exclusive. Then in that event, what will?
I will try to find out some judgment on that. And my lord, probably this petitioner is not taking steps because there are no steps.
There is a very growing which is going on in relation to a known litigations across the country. If there is a joint will, whether any of them can subsequently execute a single will, singularly. Are you?
Under Order 39 Rule 1 and 2 CPC for a temporary injunction.
Could not hear.
Application for temporary injunction was filed in the suit by the plaintiff. That was dismissed.
You are for defendant or plaintiff?
No, plaintiff.
Plaintiff.
So that was dismissed. Against that, I preferred an appeal.
Right.
Again, appellate court has also confirmed that. Against that, I have come for this.
In the revision.
In the revision. The suit was filed by me for declaration.
Was it a ex parte?
No. It was contested. Contested. So the suit was filed. I have annexed the plaint as Annexure 1, where the plaintiff sought for a declaration that a particular executed by her father in favor of the third person, the present opposite party, who is defendant number 3 in this suit, is the purely illegal.
Invalid, bad.
Yes, fraudulently obtained, etc., etc. Because that was obtained just few months prior to the death of the father. Because it was this death was in the month of September 2025, and the sale deed was on January 2025. So that was the allegation, and other parties are there. Son and mother is also there. The learned trial court dismisses the application solely on the ground that the mother is not coming for come to dispute the deed. That is the order also on the Annexure 4 I have filed. That is the only ground. That the
Mother was a witness, or she
no way connected. But that was the ground for which the learned trial court dismissed the application and placing that part of the order. Annexure 4 is the at page 38. That is the order.
Page?
Page, it starts from page 38. The RS 41.
The sale was effected in favor of a third party?
Third party. The
possession is also disputed.
Possession is joint property. He is the sister. He is the daughter of the family. He is staying at another place.
Daughter of the family is very ambiguous term.
Yes.
Please
No,
say
they
the daughter of the deceased or not.
Daughter of the deceased.
That means the plaintiff's sister.
Sister.
So this sale was in the
Plaintiff
in favor of the daughter by the father.
Father executes the sale in favor of third person, not the member of the family.
Sorry.
I'm sorry, I could not follow yours.
Think.
The father.
If I understood, you said that the father was the original owner of the property.
Yes.
During his lifetime, it appears that the father has executed a sale deed in favor of a third party.
Yes.
According to you, this execution or registration of the deed was done 2 months before his death.
Yes.
In the month of January, it is done, where he died in September.
September.
I understood.
Yes.
Now, the father, after the death of the father, then you being a daughter or a son, what?
Daughter.
Daughter. You filed this suit. I find that the opposite party means the third party in whose favor the deed is executed.
Yes.
He claimed that he is in possession of the property. I asked you a simple question, sir. The property is lying in whose possession?
At least not in my possession directly, because my mother and brother is there on the property.
So that is definitely
Yeah.
in your possession.
Yeah, because I cannot prove any rent receipt, etc., etc.
So you
It's a suit for partition. It's a suit. The suit was filed for partition, including the prayer that the sale deed is illegal.
partition against your brother and
Mother.
mother.
Yes.
So brother objected.
No objection. Only objection was raised by the stranger.
Exclusive property of your father.
Father.
Where is a portion that unless the mother comes, it will not?
Yes, running page 41, that is a part of the trial court's order. Temporary injunction was sought for seeking that it should not be alienated any further. The page 41, paragraph 5 and 6. The petitioner claimed that she used to reside at Delhi. There is absolutely no material.
Yes, your mother has disowned Your mother has said that yes, he is a bona fide purchaser.
No, there is no such statement from the side of the mother.
This is what is there.
That is being
DW2 is a mother. I mean the defendant number 2 in the written statement did not support the claim of the petitioner and mentioned that the OP is a bona fide purchaser.
No, there is no witness.
What are you talking? Where is the written statement of the defendant number 2?
There is no written statement, Lord.
What are you talking?
Pardon?
Sir, if the court has recorded something, it is always sacrosanct.
Yes.
You can't dispute it.
Yes, ma'am.
So we have to go by this.
There is no witness to this, at least to this order, to this proceeding for temporary injunction. There are no
witness.
No witness were examined.
Why it will be examined? It is always on a affidavit evidence.
There is no affidavit from the side of the mother.
All right, affidavit means the objection, sir.
Objection
on a pleadings.
Mother has not filed.
At least I have groomed it there in this fashion. There is no question of any oral evidence to be adduced on an injunction application.
Yes, ma'am. Now
I have never seen nor come across.
Now mother has not filed any statement.
But that she has filed a written statement. The court has said, come to page 41.
41.
Paragraph 4.
Yes.
Line about from the bottom of paragraph 4, 1, 2, 3, 4, 5, 6. 6th line from the bottom of the paragraph 4.
Yes, it has written. It has been written. It has been written. But
we have to go by that. We have to go by that. You just prove it. What is a fraud?
Pardon?
You prove by that the fraud is there.
Yes, that
will
is
be
I have to prove it in
but injunction?
No. I have to prove it in the suit.
No, sir. No injunction.
Because unless there is a order for restraining sale at least, because further alienation will complicate the matter. That is the only my prayer, not more than that. At least let it lie with that stranger purchaser till the disposal of the suit.
Sir, you are not disputing the signature of your father on the deed. You are not disputing that it is a forced signature. And what made? Prove it. The Madam, I have spent much efforts in reading. Why? Order 41 rules 27
Yes, sir.
rejected.
Yes, sir.
What is the ground for admission?
Yes, admission of certified copy of plot index.
What is the point of law you are making in the revisional application? Appeal is pending.
Appeal is pending.
What is the ground?
Ground
What is
is,
the point?
At the time of hearing, the appellant filed a petition under order 41 rule 27 for acceptance of plot index.
I understand.
Yes, sir.
What is the point of law you want to agitate for service of notice?
You reject the petition.
Please work on that proposition of law, whether order 41 rule 27 application can be disposed of in isolation or it has to be heard and decided along with the hearing of an appeal is the law point.
Sure, sure. Along with the appeal.
So why you are not saying? How can you decide segregating it? Notice give. What is the stage of the appeal? What is the appeal?
Appeal is assisted hearing. At the stage of hearing.
Where you are stated.
Oh.
Asked order how the court has. Any date is fixed thereafter?
Thereafter, I have no.
Appeal? Where is the impute?
Annexure 5 and it is posted to 15/4/2020.
Yes.
Last date.
An application under order 41 rule 27 of the court of procedure Requisites by Monday, madam.
26(9) application has been allowed.
Local investigation.
Yes.
Why?
Only the
What
findings
is the
that
nature
for
of the suit?
collection, nature
What
of the
is-
suit is for permanent injunction simpliciter, permanent injunction simpliciter, and it is even added demarcation of a disputed land. Nowhere despite
Is a suit for permanent injunction.
injunction,
Then why order 26 room 9 lies?
along with a prayer, in additional prayer for a demarcation of a disputed land. The disputed land has not been defined in the plaint itself. And he has filed an application. Plaintiff has
Oh,
filed
you
an
are a defendant.
I am from the defendant.
Has been allowed.
That has been allowed.
Where is the plate?
My lord, annexure 1. The lordship may kindly see the annexure 1 at page 9.
I'm really surprised. I
Prayer-
wanted to learn. How can a prayer for demarcation without a prayer for title?
Yes.
Nice.
That is not there.
First thing is that he has to assert his title and then
That was not there.
in order 26 room 9 lies when there is a boundary disputes in that.
Here the learned, he has prayed for a order 26 rule 9 for appointment of the Tahsildar to demarcate the land. The London trial court molded the prayer and allowed the civil court commissioners to be collect the evidence from the spot. That is the paragraph page 24.
Notice returnable after 4 weeks stay of the operation.
Pardon, your lordship, I'm seeking of adjournment. Actually, due to some medical emergency, my senior has to rush.
This order.
The FAO is being challenged actually.
The certificate. Where is it? Do not file the certificate copy. Item number 9. Okay, next.
Item number 10.
Why you filed it? You could have waited for it. Don't file it. If you are not ready, then don't file it. On the other day, I was taking up the old matters because I understand that those are pending. There may not be a contact, but these are fresh matters. I decided that it should be listed. So you are ready. Ought to be, should be. Why you are asking for an exception? What is the necessity of this? It is a probate proceeding. So, what you wanted to prove?
I filed an application under Order 16, Route 7.
I understood. You wanted that somebody should come and produce certain documents for the post office. What are those documents? I just
Those
want.
documents are the defendant number 2, the active in the suit matter. He has withdrawn an amount of 10 lakhs from the
account of the deceased one. And out of that 2 lakhs he has withdrawn. Transport 10 lakhs, and I want to produce that document on record, my lord. To
That is
so
what it has got any relation with the proving of the will? I'm just asking.
it has
There must be
show the
some
conduct.
material.
Will show the conduct of the defendant.
So what? The conduct in relation to a probate of a will?
That's not a question of-
No, sir. Unnecessarily. Unnecessary. What is your application?
That's my
Which
application.
page?
Annexure 1, page 15. ma'am. Page 15, ma'am. Initially, the plaintiff was filed without implementing us in this the test case form. We got to know later on we have filed an application on order 1 and rule 10, then we intervene in the proceeding.
Yes.
We want to. But initially, the plaintiff, the opposite party number 1, has not implemented us as the opposite party. We are the first line of success. my lord. We are the brother and sister.
So have you lost a caveat? Then you can interfere. There is no difficulty.
My lord, we intervene. We made a
So affidavit in support of a caveat, you must have filed it. Now it has become a contentious cause. Is it not converted into a suit? A
it
contentious
has been
cause? No.
it has been converted.
No. No. The instant
If it's a petitioner before Lordship challenging the order,
Which order?
order 1 rule 10 has been rejected. Then
Order 1 rule 10(2). Addition or striking out?
addition.
Whom you wanted to add?
The suit for cancellation of the ROR and easementary right. It's a suit for cancellation of the ROR entries and easementary right. The plaintiff, after the written statement was filed two interim applications. First one is for the amendment of the plaint, and second, the addition of the parties whom he want to incorporate as defendant number 2.
Who is he?
He is a adjacent landowner. The plaintiff is claiming easementary right over one plot. After the written statement was filed, an amendment application filed that this easementary right exists over another plot also. It is a continuous passage.
That amendment was allowed.
No, that amendment has been rejected. Same I may also challenge, that is item number 12. The same day,
Order 1 rule 10 is
also
obviously has to be rejected.
Lordship, no, but the learned trial court first adjudicate the order 1 rule 10 application on the ground that there is no pleading on the plaint regarding the plot over which I want to incorporate claiming the easementary right. Thereafter,
The application for amendment of the plaint as well as for addition of a party were filed simultaneously.
the amendment application rejection.
Item 13.
I've lodged a caveat. So copy of the
Copy is for the petitioner. You are not. Why you are not giving a copy?
We have not known about the caveat, my lord.
Is I do not know. I think it is a high time when some procedural aspect is to be looked into. Can we pass a practice direction? Are you not following that the electronic cause list? Are you not following the electronic cause list?
My lord.
Following.
My lord.
Is reflected. There is a caveat.
But we do not know the counsel Srinivas Parija.
Oh, so his name is there. So will you not serve him a copy?
No, his name is not Srinivas Parija, my lord.
I have instruction to appear in this matter. I'm engaged by.
No, sir. If caveat is lost by somebody, then he's.
Sir, my learned senior, he has lost the caveat.
I will serve in course of day.
He has lost the caveat.
So he's here. It appears that the caveat has been lost by the opposite party. Just 1 minute.
In this case,
Just 1 minute.
my pleasure. This is an application for a
No, I understood. It is a really a suit for the declaration of the title in respect of a Schedule B property,
my lord,
partition of Schedule A property, and permanent injunction
my lord.
Against the defendants. Now it has reached to the stage of peremptory hearing. I think the evidence is going on. And the plaintiff's evidence is closed. Then the defendant wanted to introduce the death certificate to exhibit the application.
No, my lord. No, not defendant. If it's introducing
Sorry, I stand there. The plaintiff intended to exhibit one death certificate.
death certificate
You
without
said
giving
that,
an
you can't after the closure of the evidence, you can't adduce.
he cannot adduce.
Correct. He cannot adduce further evidence. After the closure, he cannot mark any document exhibit.
My lord, without giving an opportunity to me. That is first.
Too technical, but substance. Under Code of Civil Procedure, where is a provision for marking a document exhibit without tendering in the witness box by the witness?
Unless one is recalled.
Or can any document be marked exhibit without being tendered by the witness standing in the witness box?
My lord.
Can it be? No.
No.
There is no provision. How can a court marked as an exhibit on the basis of application? Service.
My lord, the contracting lawyer is ill below. Let it come other day.
Who is the lawyer?
Digambar Sethi.
Yes?
Digambar Sethi.
What is your good name, sir?
My name is P.K. Samanta Singh. I have also
Sir,
power
you
in
are
this
also
case.
Mind of Agalatama, sir.
My lord, my lord.
Do it, do it. What is the case about?
I have no brief, my lord.
What is the case about?
That is the
Whether 151 is the proper remedy to recall the compromise degree? Tell me. Whether 151 is the proper remedy to recall a compromise decree, I am asking.
My lord, it was fraudulently done.
Whether 151 lies, I am asking you a very simple question, sir. You have filed 151. Whether it lies.
Will examine.
Adjourn for next. Next.
Arbitration matters.
Team
This was written.
Item 16.
Item 16.
Sir, I had sought for adjournment on the last occasion, so there was a possibility of amicable settlement during the party.
After vacation. Is submitted by the counsel appearing for the petitioner. There
Lordship, I have instruction to, Lordship, I have instruction to appear on behalf of opposite party number 1.
Which one? 16.
16, Lordship.
Sir, he is there. Contact him. He says that parties are compromising.
Lordship.
Yes.
Item 17.
It's item 17. The arbitration clause is at page 51. Arbitration clause is at page 51, my lords.
5-1.
Yes, my lords.
Yes. Which one?
Note 3.43, my lords. At 3.43 arbitration clause.
Page 51.
Yes, my lords. Of the ARBP petition.
51 is this document. There is no question of any 3.4 or something. This is a magnetic engineering work.
Yes, my lords.
18/9/2028.
Huh? Where is that?
It's 50. 50 was
50.
3.43.
Yes, ma'am.
Sorry. One page before. Yes, general conditions.
That by way of an additional affidavit, which is at flag A.
There is a GCC.
Flag A, my lords.
Of
additional affidavit. I filed one additional affidavit. That is a flag A.
Which clause?
Page is 45, my lord. 64. Clause 64.
Demand for arbitration.
Yes, my lords.
Clause 64.
Yes, my lords.
Demand of arbitration. Okay. It will be okay. Non-prevention, public demand of non-prevention, okay.
Yes. What is the dispute? What is the nature of the dispute?
My lord, delayed payment. Demand for delayed payment.
Payment?
Yes, my lords.
Where is the section 21 notice?
21 notice is at page number, my lords, 91, my lords.
Annexure 12, page 91.
Annexion 12, page 91.
But it is not a notice under the statute. Its heading is amount for relation, public demand, public arbitration.
What is? Then what it is? If it is not a 21, they have said that if you do not make, then they will go for arbitration. That is a section 21.
Yes, but this letter.
There is no format, sir, of a letter. Only thing that he must signify that the dispute has arisen, and in view of the arbitration clause, that's all.
Notice.
Yes.
So why you are not? We are appointing. Then there is nothing.
First time it is listed. Let me issue notice.
What first?
Yes.
First time
Then don't appear. Then we'll issue a notice.
Let me issue notice.
Notice. Yeah. Returnable after 4 weeks.
And we had already served copy in the last.
All right, understand.
18.
Item 18 minutes. That's the arbitration clause is in page number 21.
Yes, where is the notice?
It is at page 36.
36.
Yes.
Where is the receipt? Postal. Page 41.
Yes, minutes. 41.
Have they replied?
No reply minutes. They have not replied.
Service. 4 weeks.
Item number 19.
May I please launch it? Also, the last two occasions, my learned senior has taken time to suggest their nominee arbitrator, my lord.
I have seen that all these appointment of arbitrators are accused to appear as a arbitrator. Justice Bini Saran is recused to.
Okay.
Then Justice Deepak Mishra is recused to do so.
So this is substitution of an arbitrator.
Yes.
So I don't know
Justice
many arbitrators.
Akhairath may be is our High Court. Justice Akhairath, he may from our this High Court may also.
Justice
Akhairath, Dr. Akhairath.
You have to suggest the nominee arbitrator, my lord. We don't have problem. The place arbitration will be in Delhi.
So have you obtained the consent?
From Dr. Rath.
Who is the principal? I mean he is a
Yes, my lord.
So
We have already nominated our arbitrator, my lord.
Justice Krishna Murari also recused to. Justice Krishna Murari, he also recused to accept.
The proceeding which is at Lordship's page 147. That was a proceeding when two of the arbitrators are recused because they didn't agree to the fees. That's why my lords directed them to take instruction who will be their nominee arbitrator.
Now
the
the
two
question is
occasions-
that there because both the arbitrators are recused to arbitrate. Now it would have
taken a consent
from Dr. Rath.
Yes.
Just let me give 2 minutes time.
We can.
I don't think that he is not recused. Still, then I will take within lot give me 2 minutes time. Just pass over one pass over and
on the next matter.
Item 20.
40, your lordship, the conducting counsel's father is passed away. Kindly answer me.
An accommodation is sought on behalf of on
Item 21.
21. The arbitration clause is at page 18, clause 40. 18.
This is against the law.
Yes, my lord. Unilateral clause, lordship.
Yes.
Then
Where is the notice?
21 notice at page 41, 41.
Non-payment.
Yes, my lord.
Where is the service?
Page 46, lordship.
Service. 4 weeks. Next.
Item 22.
22 minute, please, my lords. That's the arbitration clause is at page 17, clause 13, my lords.
Huh?
My lords, page 17, clause 13 is the arbitration clause. My lords.
Yeah, where is the
My lords, 21 notice, your lordship will
Notice.
find page 25, my lords.
service?
My lords, service at page 29.
Notice.
Item 23.
If I may please your lordship. The arbitration clause is at page 66, my lord. Clause number 24.
Then let them serve a copy. I didn't have a copy of this.
East Coast Railway.
East Coast Railway.
You are there?
Yes, we are here.
Serve a copy. Yes, sir. Because the learned DSP intervenes in the process.
Item 24.
Take his
My lord, item 19. Justice Ratha has given consent. He didn't have any objection.
I will dictate.
Dr. A.K. Rath. Yes. Oblige.
You just give the full name.
Yes. Akshay Kumar Rath. I will just go.
Sleep.
Next.
My lord.
Item number 24.
Appointment of arbitrator, my lord. There is a arbitration clause, my lord.
Where is?
Running page 11, paragraph 18.
11.
11. Running page 11, Annex 1, running page 11. Paragraph 18, my lord.
Very difficult to read, sir.
That in case of dispute, the matter shall be referred to single arbitrator.
But there is a stamping and all, everything, the photocopy.
Yes, next.
Anyhow, yes, where is the notice?
We have not sought the notice, madam.
Then how can you invoke section 21?
I
will have to seek for a appointment of the arbitrator. Say the dispute has arisen.
My lord.
Where is that?
Yes, I have taken the grounds, my lord. That they are not trying to settle the matter.
I am again asking, sir. There must be a notice that the dispute has arisen. Otherwise, it cannot be.
There is a suit also lying before the civil judge in the senior division passport, madam.
You can take plea under section 8. Have you taken plea under section 8?
Yes, no, madam.
Sir, ponder upon it. It is not maintainable according to me. Unless you intimate that the dispute has arisen and by virtue of arbitration clause, it has to be decided.
What happened? The shop was closed since more than 1 year.
Maybe.
About more than one.
It's a partnership dispute, I understand.
Yes, madam.
Whatever, but you'll have to give a notice, sir. That's the mandate. Very difficult. Will you continue? Then we'll have to dismiss or you withdraw. First, you communicate to him the dispute has arisen, and thereafter you come. You can definitely.
Item 25.
Lord, I beg to appear virtually in this matter. My lord, the arbitration clause is at page 83 of the petition. My lord, is GCC clause 25.
Just 1 minute. Yes. Where is the notice?
My lord, the notice of arbitration is at page 165. Annexure 8, my lords. And my lord, this was followed by a notice of appointment of our arbitrator. Because my lord, the arbitration clause contemplates.
Where is that?
My lord, the subsequent notice is at page 194. Whereby, my lord, we nominated our nominee arbitrator, Mr. Manoj K. Mishra.
Service. Notice. Next.
Grateful, my lord.
26.
Page 30.
Arbitration clause.
Page 37. The jurisdiction also looks at all disputes and differences that may arise between the parties.
Yes, yes. Where is the notice?
Notice is page 89. Annexure 6.
The dispute between a developer and the owner.
Developer, yes. They are not
Notice.
doing anything keeping matter.
4 weeks.
Right.
Item 27.
That appears 4 weeks.
Your Lordship, appearing through VC, my Lordship.
Appearing for VC or appearing on VC?
Appearing on VC for item 27, my Lordship.
Here is the arbitration clause.
Page 21, my Lordship. Clause 35 in the page 21, my Lordship.
There is a notice.
My Lords, the page at page 42, and the receipt of the notice is on page 46.
Notice 4 weeks.
Obliged, my Lords.
28.
28 times more time. Last occasion I seek for instruction. They are asking for another 10 days.
My lord, may kindly see your lordship's last order 31/2026. Already, my lord, my only prayer is already 4 months has passed, my lord. It's
Difficulty today, come in the next week. Let it appear in the next week.
Obliged.
Item 29.
my lord, as a la
29.
Just 4 weeks. Huh? Yes, 4 weeks.
Madam, I am appearing on behalf of the opposite party, my lord, the non-being private financer, my lord. In this case, my lord, my lord, item 29.
29 is adjourned for 4 weeks.
Item 30.
Well, I have not received copy, my lord.
Nobody is here in 29, sir.
Item number 30.
Lordship, the arbitration clause is at page number 36. Page number 36, arbitration clause.
There is a notice for amicable settlement.
Lordship, page 106, 106.
Subsequent notice.
Lordship, 108. And the receipt is at 109.
Notice.
Obliged.
Item number 31.
My name is Siddhartha Mishra. I have not appeared. Subsequently, I have appeared and obtained the receipt in the registry. My lord, the arbitration clause is at page 22. Top, my lord. Number is 25. Clause number 25. Okay.
Yes. No, what is this?
Which one, which matter is?
This my number is ARBP number 9 of 2026.
What is this? This is an order passed by the collector.
Collector has approached by the other side and collector has passed such an order.
No.
Madam,
Where is an arbitration?
madam, that is page 22.
No, sir, that is a part of the order of the, or that is the order of the collector.
Yeah, page?
Annexure 1.
Annexure 1. Sorry, madam.
Yes, page 22, my lord.
Page 22. My paging is wrong, my lord.
Yes, no. This page 22 is a continuation of page 20. Page 20 is hearing and disposal of a petition filed by the authorized signatory of such and such on 28/1/2026.
Page 12 it starts, annexure 1.
That is, I find. I just wanted to know where is the agreement signed by both the parties.
Page 12, my lord.
Yes, clause play page.
So page 22.
Sir, what you have done a mess.
No,
what is going on?
Then, my lord, on scanning, there is a page 22, my lord.
Page 22.
My lord.
Yes, 25. You are correct. There is a notice.
Notice, my lord, is at annexure 3, page 15. My maybe mistake, my lord.
Annexure?
Annexure 3. Registration receipt is at the bottom. Next page.
What is this notice, sir? I do not find out from the notice that what dispute has arisen.
My lord, regarding money.
Sir, where is a reflection at page 15?
Mobile tower is installed.
Sir, I am asking you, there it contains 4 paragraphs, 3 paragraphs. One, where you have said that dispute? What is a dispute?
That is not there.
Then there is a defective one. The defective one.
I shall come to my lord after complying. They replied it, then next annexure.
Reply is also very vague. He has said all the things. What is the compliance? What are the things? Nothing has been spelled out. What to do, sir? This.
So liberty to comply the notice, then.
Then what? Then you will have to do something with this.
Oh, I will withdraw this.
Yes.
Lordship may grant me liberty so
He
that.
has liberty to approach for the self-serve relief.
Item 32.
No, item 32, the arbitration clause is at page 100.
Page?
100. 133. It's part of the general conditions of. The It's a tier system. First, there's a conciliation proceeding.
That is what I was just thinking.
Yes, my lords may see annexure 4. The conciliation was annexure 4, page 163. The conciliation proceeding was invoked by the opposite party. And then during
Yes, sir.
163, annexure 4. Yes, my lords. It was invoked by the opposite party.
Yes, yes, I understood.
Yes. Then, while it was going on, there needed to be a substitution of the conciliator, for which we sent a notice on 31/7/2025. That is at annexure 6, page 169. And there was no reply to this notice by the opposite party. And subsequently, a reminder was also sent.
Notice. 4 weeks.
Item 33.
Item 33, my lord, I am appearing for opposite party number 2. After my noting is notice is not something I have entered appearance, I filed my vakalatnama. I have sought for instruction, complete instruction. Let it come next week. I will address it.
Your Lordship, opposite party number 1 has been taken over by opposite party number 2.
Yes, yes, I am appearing for.
Opposite party number 1 also, their appearance may be recorded.
Yeah. Next week, adjournment on behalf of the opposite party number 2. Which is
Obliged.
Item number 4, I am filing the memo petition, Your Lordship. For item number 4.
What has happened to 4?
It's for dictation, or it will common for orders in next week. We dictated now. That is illegally.
Oh.
Yes, Your Lordship.